Hi everyone, welcome back to Civil Procedure. A lot of ground to cover today. We're going to try to wrap up pleadings and get into service. Okay, so let's go on with our pleadings. You recall for this from last time, statement of defense following the statement of claim, and then we have this counterclaim. But a counterclaim would be used if the defendant alleges that the defendant, have suffered some sort of damage arising from the plaintiff's conduct, right? So it could be, a counterclaim could be a new suit if the defendant had sued first. But because the plaintiff sued first, the defendant now puts this independent actionable wrong into a counterclaim. And correct that effectively turns the plaintiff into a defendant within that suit, but it remains the same suit. So if you're the defendant and you're in a position to issue a counterclaim, you would put the material facts grounding that counterclaim into the same document that contains your statement of defense, and at the top it would say statement of defense and counterclaim, and there's a separate form on the Ontario Court Forms website for that. And you basically lay out your statement of defense, and then you put the counterclaim after the last paragraph of your defense. And it's just like a statement of claim ways. You have to have the material facts, you have to specify the nature of the remedy claimed, and you have to have your points of law in there, and so forth. So there's a rule about this that you read, 27.01, that a defendant can use this to claim any right that they can normally make a statement of claim out of, including a claim for contribution or indemnity under the Negligence Act in respect of another party's claim against the defendant. So what does this mean? What's this contribution and indemnity business? Right. So if there's some other party that should be blamed according to the defendant for the wrong, then they can bring them in as part of the counterclaim, and that will get us into a third-party claim, which we're going to talk about a little bit later. Okay, so counterclaims. A counterclaim will very often arise in commercial litigation, right? Because typically, if you have two parties who are in some type of business relationship previously, and then that business relationship falls apart, and they can't find any way to resolve their dispute outside of court, they'll end up in commercial litigation, and each side will have some complaint against the other, right? And who's the plaintiff and who's the defendant is just sort of arbitrary. It's a matter of who happens to claim first. So you're very likely to see a counterclaim because each party will have something that they take an issue with in terms of what the other side did. Okay, so these counterclaims are things that arise from the same sort of factual nexus, because counterclaims are all about efficiency, right? The idea is that if you've got two parties and each of them has a claim against the other, but there's a common factual nexus, a common set of things to be proved that will allow justice to be done with regard to both of those claims, it's efficient to have those things together in one suit, so the court can dispose of it all together. So if your counterclaim is completely unrelated to the plaintiff's claim against you, then the court can strike it out. Okay, so this counterclaim business is relatively new in the sense that we've only been doing counterclaims for 150 years, which makes it new in the context of our antiquarian civil litigation system. In 17th century England, counterclaims were not allowed. So when you had a business relationship go awry, you would have dozens of claims going back and forth from all the different parties involved. And the counterclaim was developed as a way to lend efficiency and reduce the number of times that the same facts would have to be canvassed en route to a successful adjudication. Okay, So it's important to note that defendants can add new parties when they make these counterclaims. As we mentioned when we talked about contribution and indemnity. So that's a way the defendant can bring new parties into the suit. So we'll talk about multiple parties in a little bit, but I'll just say that for the moment. And then, of course, the plaintiff will issue a defense to counterclaim to the extent that they have a defense to raise to whatever it is the defendant has said against them. And reply, we'll also get to it in a second. Courts of Justice Act Section 111 in your readings, they talk about this idea of set off or mutual debts. So this often comes up in a counterclaim, and basically the idea here is that the plaintiff's statement of claim says the defendant, you owe me $100, and the defendant says, plaintiff, you owe me $150. Then basically you can subtract the 100 from the 150, and it comes out with the plaintiff owing the defendant $50. Right? Again, something that happens in commercial litigation. There's a set off where the defendant saying, you know, even if we did that bad thing and we owe you a certain amount of money, that has to be set off against the larger amount of money that you, plaintiff, owe us as a result of the greater wrong that we suffered. Okay, so that can be either in a defense or in a counterclaim. You can use these ideas if you are on for the defendant. Mutual debts, pretty much a similar idea. Okay, and this is true. This is true even if the reason why, even if there are different legal reasoning involved, right? So if the plaintiff brings a suit in tort against the defendant and the defendant's counterclaim relies on contract law, that does not prevent the court from using set-off, from applying one debt to the other and making a judgment just for the difference. Okay, let's look at this business of reply. Okay, so replies. This is a pleading that the plaintiff, in some cases, will issue after the statement of defense. So who can tell us when is a reply allowed? Because it's not every case in which the plaintiff has the right to issue a reply. Different version of facts. Yes, that's right. That's right. So this is here in Rule 25.08. The reply is allowed when a party, the plaintiff typically, intends to prove a version of the facts which is different from that pleaded in the opposite party's defense, if and only if those facts have not already been pleaded in the claim. So this is also used, the reply is also used in the case of an affirmative reply, where the plaintiff has a defense to the affirmative defense in the defendant put forward, which, if not pled, might take that defendant by surprise. Okay, so it's a complicated idea, but basically there's two reasons why you might have the right to issue a reply. So first of all is this different version of facts. Okay, and then the other justification for a reply is anything in general that is needed has to be on the table, has to be considered, and has to be the subject of discovery and the subject of adjudication. If it's not, if it hasn't already been put on the table by the statement of claim or the statement of defense. So those are the two specific circumstances in which a reply is allowed. And importantly, if you can't fit yourself into one of those two categories, you may not issue a reply. So, so you don't issue a reply if you simply deny everything that the defendant has said. Okay. So, couple more rules here about replies. You're deemed again to admit the allegations that you do not dispute in your reply. So again, in this sense, the reply is putting it's kind of like the plaintiff's defense to the affirmative defense that's in the defendant's statement of defense. So there's that same deeming of admission there. Okay, so 25.09. Right, so we talked about that, and this again is the same version of the rule you saw with defense. So it's probably best to think of 25.08 sub 1 and sub 2 as, they're not necessarily exclusive. They kind of support each other. They're both getting at the idea of avoiding surprises and of ensuring that any new assertions that are going to require proof and adjudication are put on the table. Yeah, so I was perhaps wrong to suggest they're different categories. They're slightly different ideas, but I think they support each other. Okay. So let's talk now about the close of pleadings, right, where there is no reply and there are no extra parties to be brought in. The pleadings are going to close, which means we're going to get into the motions, the procedural motions, if necessary, and hopefully get into the evidence, right? Now that everything's been put on the table, we have to get at what the truth actually is, and we have to test the competing factual claims made by these parties so we can hopefully settle it, or if not, adjudicate it on its merits. Okay, so let's talk a little bit about pleadings in cases with more than two parties. So these were not in your readings, but I did want to sort of take you through it. So first of all, we should know that the plaintiff can sue multiple parties. A statement of claim can name multiple defendants. Okay, then we have, so obviously both defendant 1 and defendant 2 have the right, would have to issue a statement of defense and have the right optionally to issue a counterclaim. In which case the plaintiff can issue a defense to the counterclaim, and if the rules permit, a reply. Cross-claim arises if the plaintiff has sued multiple people and one defendant claims against another defendant. Then we have the third-party claim. Okay, so the third-party claim would be if the plaintiff has only sued one defendant, but then the defendant wants to bring in a third party, right? And that third party would be someone whom the defendant claims is, the first defendant actually claims is responsible for the plaintiff's loss. So this can go on forever, right? It's not limited to 3 parties. You can have 4, 5, and 6 party claims. It gets to be a mess, we'll see pretty quickly. And that's why we have things like class actions and other mechanisms to deal with litigation involving large numbers of parties. But technically, this procedure of bringing in new parties through pleadings is always open. And once all these parties are in, they can bring cross claims and defense to cross claims against each other. Okay, so Komal is asking what it looks like, a third-party claim. And I don't have one that's filled out, but if you go to ontariocourtforms.ca, you'll see there's a form here. This actually isn't going to tell you too much, but all of these things have forms, right? So third-party claim, third-party defense, you can probably guess what that is, and then reply. That's why there's 100 different things here, right? Because every time a party in civil litigation issues a pleading, it tends to have a special name based on where it fits into that conversation. Okay, let's look at particulars. So you already know that you need to plead all the material facts that are necessary to ground your claim. And that's true of a statement of claim. It's also true of any affirmative defense brought forward by a defendant or a reply issued by a plaintiff. And in the Witten case, which you remember from last time, the bad guy defendant insurance company said plaintiffs, the Witten family, have not pled sufficient material facts to ground their claim to punitive damages. And therefore, says Pilot, they should not have been awarded punitive damages by the trial judge. Justice Binney, of the Supreme Court of Canada, said at paragraph 89 that if the respondent was in any doubt about the facts giving rise to the claim, it ought to have applied for particulars. And in my opinion, it would have been entitled to them. Okay, and this is the rule about particulars, where a party demands particulars of an allegation in the pleading of an opposite party, and they're not supplied, the court may order them to be granted. But that still doesn't explain what these things are. What the heck are particulars? Okay, so the idea explaining this comes from this case, Copland versus Commodore business machines. I had one of these growing up. They are a ton of fun. Particulars. Okay, yes, we'll get to the motion for particulars in a second. Okay, so let's just talk about the facts of this case because it kind of puts the idea into a good context. So the plaintiff, Mr. Copland, and he brings a wrongful dismissal suit against Commodore. The motion. What was the initial lawsuit about? What was the employment law dispute between these two parties? Okay, good. So they give all these reasons why they fired him, but why? I mean, if you're an employer, you're allowed to fire your employees without providing reasons. So why is Commodore listing all these reasons why they fired him? Anyone maybe take employment law can tell us why a defendant employer would bother listing all these bad things that he allows? So yeah, with cause is the key point, and it probably is a affirmative defense. That's probably the best way to characterize it. Okay, so firing him for cause, and what does it mean? What's the legal consequence if someone is fired for cause? Difference is severance or notice, right? Notice pay. So in general, the employer can fire the employee whenever they want to, but they have to give them notice pay, right? You have to give people a certain number of weeks of pay in lieu of notice if you're going to fire them, unless you are firing them for just cause, right? So just cause means the employee did something so bad that the employer is entitled to fire them without providing any notice, right? So this is known as the capital punishment of employment law, and it's a very serious thing because about half of Canadians, live on a paycheck-to-paycheck basis, and if they're fired without any notice, that's a very difficult thing to live with. Okay, so Commodore is saying he did all this bad stuff, justifying termination for cause. And in the case, you read a summary of all these things he did. It sounds like he was living a grotesquely high-handed kind of rock star type lifestyle, abusing his expense accounts, riding around in limos, not repaying money he sort of repaid. He was insubordinate, talking back to the boss, and all that. Okay, so that's what the defendant says. Copland, in response, says that your statement of defense, Commodore, is substantively inadequate because you failed to give particulars. And the court at paragraph 11 talks about what particulars are. So the court says, in between the concept of material facts and the concept of evidence is the concept of particulars, right? So you remember we talked about material facts and evidence, and we know that material facts should be in your pleading, evidence definitely should not, but the line between them is kind of blurry. right? Sometimes something will be considered evidence if it's simply a more detailed or specific type of fact. And when drafting pleadings, you have to kind of learn basically by experience, how detailed to be without crossing the line into evidence. So now, to complicate the picture further, we have particulars somewhere between material facts and evidence. Paragraph 11, these are additional bits of information or data or detail that flesh out the material facts, but they are not so detailed as to amount to evidence. So particulars are things which could have been in your pleading, and if the court orders you to provide particulars, that means they should have been in your pleading initially, but again, not so detailed or concrete as to constitute evidence. So, so the motion for particulars. So you can request particulars of the other side. You don't have to bring a motion, right? And it's common for a party to civil litigation to request this. And yes, they do apply to both sides, because either side can be in a position of needing to know more about the other side's claim. So particulars will typically be requested informally through communication between lawyers, but then in the background, if they're not provided, there is this ability to bring a motion. And a motion, you recall, is a request for a judicial order short of trial. So a motion for particulars would be a request for the court to compel the other side to provide particulars. So, so what does this mean for these guys? What sort of particulars do Copland want? Yeah. So detail, not so much detail about the entire employment relationship, but detail about these specific wrongs that Copland is alleging, right? So I think these are good ideas to look at paragraph 3 and paragraph 9 of this, where we see, so paragraph 3 onwards, we see all of the things that Commodore said he did wrong, abused limousine and entertainment privileges, and the plaintiff seeks particulars of when he abused these privileges. So he wants them to say, on April 14th, 1983, you said you had to take a limo to wine and dine some influential client. In fact, you were just joyriding around the Canadian Tire parking lot. So everything that they've said, he's basically saying, what do you mean? When did I do that? How did I do that? You've got to give more details of what happened. Okay, so in paragraph 21, the court talks about the specific level of the different levels of material fact disclosure, right? So this is all about how detailed do your pleadings have to be? And there's a suggestion here that the answer to this question of how detailed your pleadings have to be depends on what kind of litigation we're talking about, right? Here we're talking about very serious allegations, right? The garden variety, 95% of wrongful dismissal claims, the defendant will not allege cause. 95% of wrongful dismissal claims, the defendant will say, we're firing you without cause, and we're going to give you notice, pay in lieu of notice, and the dispute will be about how much pay in lieu of notice you should get. This is the the serious type of allegation that an employer can make against an employee, which is that you screwed up so badly that we don't owe you a penny, and if you don't have savings to rely on, then maybe you'll be at the food bank next week, right? So this is really heavy stuff. And that's why the court says, where the defendant employer relies on cause for the dismissal, the minimum level of material fact disclosure is very high. We're not going to let defendants get away with just throwing around allegation just cause willy-nilly, because if they were able to do that, and they could put this in every defense to every wrongful dismissal claim, that would give the defendant a major tactical advantage. the plaintiffs would be driven into settling for pennies on the dollar of what they're actually owed, because they're confronting a risk of a being found to have provided just cause for dismissal, and therefore walking away with nothing. So in cases like this, where there's a very serious allegation made, there may be a higher level of material fact disclosure required. Okay. The pleading must contain sufficient detail so that the employee and the court can ascertain the exact nature of the questions to be tried, and so the employee can meet the charge and respond in his reply accordingly. So this defense was not good enough, right? And you can see the kind of things they're talking about. It's not good enough to have these like subparagraphs here where you just kind of, I mean, these subparagraphs, oh, he abused this, could just be like the executive or the defendant's lawyer just kind of thinking, well, what are all the bad things that an employee might possibly do, right? They might have a sex account, they might have been insubordinate, and then just kind of throwing it all at the wall. And that's not good enough unless you can back it up with material facts. Okay, so this statement of defense was not good enough according to the court. Instead of granting the motion for particulars, the court struck out the defense and granted leave to amend, which basically means the defendant gets another chance to issue their statement of defense. It's sort of an interesting example of the inherent discretionary power of the court. The remedy that the court granted here is actually something that no party was seeking. Right? The plaintiff wanted an order of particulars, the defendant wanted no order, the court goes and orders something else. But it kind of comes to the same thing, right? Because if the defendant is going to be issuing another statement of defense, the court's going to require that revised statement of defense to contain all the missing particulars. So effectively, it comes to the same thing. Let's look at this Rotsein case, which was not in your readings, but I wanted to show this to you as an example of a successful motion for particulars. Okay, so this is Nancy Rotsein. She published this book called Shattering Glass in February of 1996. The book was published by a prestigious publisher called Farrar Straus, based in New York City. So in May of that year, the Globe and Mail runs this article of Nancy Rotsein with her husband, Maxwell. So Max is a big shot executive and a millionaire. And this article suggested that Mr. Rotsein invested hundreds of thousands of dollars in book publishers that later ended up publishing his wife's work. And that he was in fact buying her a profile in publishing that her writing talents alone might never have won. Right, so basically they're saying that they financially they kind of bribed this publisher to publish this book. That the sales figures of the book had been artificially inflated, and the book was no good, and it was just like a vanity publication. So Nancy Rotsein now sues the Globe and Mail for defamation. And her statement of claim says that the words of the article in the context of the entire article had meanings or were understood to have meanings or innuendos which are false and defamatory to the plaintiff, because obviously this claim is very damaging to her reputation. The Globe and Mail files a statement of defense which says that insofar as the meaning ascribed to the words complained of by the plaintiff are fact, they are true in substance and fact. And insofar as they are comment, they represent fair comment on a matter of public interest, namely criticism of literary work which was submitted for public scrutiny by the plaintiff. But basically, if something is sort of put out there in the public, like a book, you're allowed to talk about it, right? And you can publish things about it which may damage the reputation of the person who put it out there. But there's scope, right? Because defamation law is all about a plaintiff who has suffered a quantifiable monetary loss by virtue of their reputation being run down by the defendant. and providing a remedy for that. But the whole idea of defamation runs up against the idea of freedom of speech, freedom of expression, right? And the law does not want to expand the concept of defamation so much that no one can write newspaper articles about public figures or say what they think. So fair comment is a defense in Canadian defamation law, right? If it's a matter of public interest, then you're allowed to kind of say what you want about it. We definitely don't want a situation where you can't write a book review in the Globe and Mail of a book without being sued for defamation if you write that the book is lousy. Okay, so this is one of the defenses to a defamation suit. Another defense to a defamation suit is truth, right? It is never saying something which is true or writing something which is true can never, by definition, be defamatory. So, so this is basically the essence of their statement of defense, right? They're saying that either what we wrote is true, or if it's not true, it's fair comment, and therefore either way, we're not liable in this defamation suit. So Rotsein comes back and with a motion for particulars. She says, before the plaintiff can begin to understand the charge made against her in the article written, she has to be told which of all the words she complains of were offered as facts and which words were offered as comments on those facts, right? And the court says, yeah, this defense is not good enough, right? I mean, yes, truth is a valid defense, and so is fair comment. But Rotsein has to know which part of this is supposed to be true and which part of this is supposed to be fair comment, because that's the only way that she'll be in a position to lead her own evidence about why it's not true, right, or why it's not fair comment. Therefore, the motion for particulars is granted, right? It's ordered that the defendant provide particulars of these paragraphs as set out in the notice of motion. We can kind of move on. The whole idea of particulars is it's facts. They're things that could have been material facts, probably should have been included as material facts that a party can be required to add in order to ensure that all the facts are on the table, and we can move forward towards finding the truth, hopefully. Okay, so the last thing we need to know about pleadings is amendment, right? Amendment is just a fancy word for underlined material. So underlining is how you know that there is amendment in a pleading. If you're amending your pleading, you should underline the new stuff that you're adding. Okay, so our case on amending pleadings is this one, MacDonald Construction versus Ross. So it's a PEI case, so the rules are a little bit different, but the law is fundamentally the same. And I think the case is a good review of some of the key principles around pleadings, as well as illustrating this specific point about amending. Okay, so old MacDonald had a farm, E-I-E-I-O. On the farm, he had a fire, which is bad news. The good news is that the building was insured. The barn that caught on fire was insured. But the other bad news is that he got no money from the insurance policy. He was not able to successfully claim against the insurance company to compensate him for the loss of his barn. So let me ask you this. Who was this Ross guy? And why did MacDonald blame Ross and sue him?
Ross was his solicitor, who had instructed him to basically fill out the proper, or like go through the insurance policy to get the money, but he did so at too late of a date, and so he wasn't eligible for the money.
That's right. That's exactly it. Yeah. So Ross was MacDonald's lawyer. And Ross was asleep at the switch, MacDonald said, stalled too long, and they ran out of time. So an insurance policy is always going to require the claim to be made within a certain period of time after the incident giving rise to the claim. And what this is a professional negligence suit. It's not exactly a statute of limitation because so statute of limitation prevents people from bringing civil actions about events that happened too far in the past. This is about the insurance contract, right? So if you're a party to an insurance contract, you have to bring a claim for insurance quickly enough after the incident occurred. Okay, so MacDonald versus Ross started off as a negligent professional negligence suit. As you'll learn in the legal profession, or maybe you've taken it already, if a lawyer screws up, they can get in trouble with the Law Society, but they can also be sued by the client for whatever loss it was that was caused by that negligence. At the trial, how did Ross, the lawyer, defend against the solicitor's negligence? What people are getting at here? Yeah, it has to do with the vacancy. That Ross claims that even if he did wait too long and he screwed up, he should have brought the claim earlier. Even if he had brought the claim, MacDonald would not have got anything from it because this barn was vacant. Insurance policies. Well, let me ask you, why is it that the vacancy of a building is relevant to an? Yeah, Danielle's got it, right? Buildings that are vacant are much more likely to catch on fire, burn down, flood, and so on, because there's no one around to take care of them. Okay, so the insurance policy would have excluded claims on vacant buildings, or at least MacDonald would have had to tell them that it was vacant. Yeah, Mallory got this. Would have had to pay a higher premium to have insurance on a vacant building because of the higher risk confronting the insurance company. Okay, so this argument that Ross is making is reasonable enough on its face, right? If it was vacant, that doesn't change the fact that Ross was negligent in waiting too long to make the claim. But the vacancy argument would eliminate all the damages, because even if Ross had done his job properly, MacDonald still would not have got anything from the insurance company. Okay, so what did Ross, the defendant, the lawyer, what did his original statement of defense say about vacancy? Nothing, exactly. This was not in his statement of defense. We don't know why not, right? Maybe Ross didn't know it was vacant. Maybe it didn't occur to him. Maybe he's not the sharpest overall knife in the drawer. He just didn't get this in his statement of defense originally. But from the judge's point of view, you want this vacancy idea to be properly considered and adjudicated, right? If you want to get it right, you don't want to go ordering Ross to pay damages to MacDonald when MacDonald actually did not lose anything by virtue of Ross's negligence because of the vacancy piece. So why then, assuming the system wants to know about the vacancy thing, why is it problematic when Ross tried to bring up this vacancy argument at the trial? That's right. So it's a violation of the no surprises principle that we've already talked about. It's what's known technically as a variance. It's a variance, right? If you try to raise something at trial that was not identified in your pleadings, that's called a variance. Trying to prove a fact or make an argument at trial which was not in your pleadings. That was not in your readings, but we'll talk about variance when we get to trial itself. And generally, variance is not allowed. Okay, so Ross has a comeback to this, right? What does the defendant Ross say? Why does Ross claim that he should be allowed to raise this at trial, even though it does not appear to be in his statement of defense? That's right, Danielle's got it. The defense was implicit in his pleadings. And what part of Ross's initial statement of defense made this vacancy defense, or implicitly raised this vacancy defense, according to the defense? Bingo. Paragraph 4. The defendant does not admit the plaintiff suffered the damages alleged or at all. So the judge does not buy this, right? The judge said, paragraph 4, I'll just highlight it so people got it here. Okay, so this is a complement of facts here, but oh yeah, this one here, right? This one. The defendant, Ross, the solicitor, is saying that I told the plaintiff in my statement of defense about the vacancy argument. And how did I tell the plaintiff? Well, I told the plaintiff right at paragraph 4 where I wrote that I don't admit that you suffered the damages, right? And Ross says this implicitly includes the idea that you did not suffer the damages because the building was vacant, and therefore you never would have got anything from the insurance company no matter what I'd done. So this does not fly, right? And the judge at paragraph 11 describes this as a simple traverse, which is to say formally denying the other party says, a statement of defense, which, the judge says at paragraph 11, in effect does little other than put the plaintiff to the proof of his allegations. It does not alert the plaintiff to the line of defense which the defendant intends to advance. That is to say, the plaintiff was in breach of his insurance contract, etc. Right? So that's the policy of surprise, against surprise, right? That you know, MacDonald, the plaintiff, got at most only a hint at the evidence stage about this vacancy business. MacDonald deserved to know that this vacancy thing was on the table, because what might MacDonald want to do? What legitimate steps might MacDonald take if he is alerted to this? Reply. I think this could well be a good appropriate circumstance to use a reply. And what might the substance of MacDonald's reply be? That it was not actually vacant. Yeah, that's right. That's right. So there was someone there. It wasn't vacant, or maybe, you know, I'd alerted the insurance company to its vacancy, and I was, you know, paying to have it insured nonetheless. Any further? But there's also this, right? So this is a good statement from MacDonald versus Ross of the kind of theory behind pleadings and of the no surprises doctrine. You have to frame pleadings so they contain all material facts and matters in a manner sufficiently clear and concise to present the nature of the claim or defense of the opposing party will not reasonably be taken by surprise. All right, so that's amending pleadings, or the idea of amending pleadings, and in this case, the court ends up granting the right to Ross to amend his pleadings to bring in the vacancy idea. But let's look at the specific law on this in Ontario. So we have 26.02 sub A. A party may amend the party's pleading without leave. So leave is just the permission of the court to do something, and so this means you don't have to get the court's permission to amend your pleadings before the close of pleadings if the amendment does not include or necessitate the addition, deletion, or substitution of a party to the action. Okay, so what does this mean? The close of pleading. Oh yeah, 25.05, right? Pleadings in an action close when the plaintiff has delivered a reply to every defense in the action, or has run out of time to do so, and every defendant who is in, well, the default part we won't get to, but basically, you know, the plaintiff in a two-party action has the right to the last word if and only if the facts permit a reply. Right, so if the plaintiff has the right to issue a reply, then after they do so, pleadings are closed. Or if they don't have the right to issue a reply, or they elect not to, and the time for delivery of that has expired. So the time for delivery, we're not going to get too much into the timelines. because the timelines are always changing. But basically, the timelines for pleadings are pretty quick. They're like a matter of days, or 10 to 20 days are allowed between the first, like the statement of claim and the statement of defense, and then reply after that. So there's timelines. They're short, but timelines in pleadings are very often waived on consent. So it's quite common for the defendant to ask the plaintiff for extra time to issue a statement of defense, and if the plaintiff does not grant that, the court might grant that as well. These rules tend to be kind of flexible, so we're not going to deal with the timelines in too much detail. But I'm just raising them now to explain this, right? When pleadings are deemed to have closed, and they're deemed to have closed after the reply, or if the time for issuing that reply has expired. Okay, so we've got this rule that says you can go nuts, amend your pleadings without asking anyone's permission, statement of claim. And what's more, even if pleadings have closed, you're still not necessarily out of luck if you want to amend, right? So, this is not like law school, right? Here in law school and throughout university, if you hand in an essay and then the deadline passes, and then after the deadline for the essay, you have a brilliant brainwave and there's this terrific argument that you want to put into section 2, you cannot do so, right? You can't amend your essay after you submit it. By contrast, you can amend your pleadings, you can at least seek permission to amend pleadings after the close of pleadings. So you can do so on motion at any stage of an action. Any stage of an action, right? Right up to trial. And this is what Ross was doing, right? So Ross, in the MacDonald and Ross case, he said, look, either I want to raise this variance thing at trial because I pled it implicitly, that didn't fly, but he said, or I want permission to amend my pleadings to put the variance argument in, even though we're at trial, and that the judge did in fact grant. Right? Because we have a liberal approach to pleadings. We have in Ontario, right? So a strict or a conservative approach to pleadings would be get it right the first time, guys. Don't waste everyone's time, taking a second kick at the can. Put the argument in the statement of defense, and if you don't, forget about it. That's not what we do, right? Instead, we have this liberal rule. Where you're allowed to amend your pleadings at any stage of an action on such terms as are just. So why? Why is the court so liberal? Why is the law so liberal about pleadings? Why not treat Ross the way a professor would treat a student trying to amend their essay after they've submitted it and after the deadline for the essay? And if there's a substantive fact that would determine the outcome, we don't want that to be obscured by the fact that someone forgot to put right. Yeah, and I think people are noting properly in the comments here that the settlement rationale is also there, right? Getting everything on the table increases settlement potential. There's something else here too. If you're, if you're sued and you have a great defense and it doesn't end up in your statement of defense, whose fault is that? Is it your fault? Your lawyer's fault, exactly, right? So things that are overlooked and left out of a pleading will typically be the fault of a lawyer if the party's represented. And to prevent those facts from, or those arguments from being put forward and prevent the party from having the benefit of them would be unfair if it's the lawyer's fault. Okay, so this is all part of this idea. So Rule 1.04 in the Rules of Civil Procedure says that the rule shall be liberally construed to secure the just, most expeditious, and least expensive determination of every civil proceeding on its merits. And it's an idea that we'll see reflected at various points in the course material, that we're not going to be as harsh. Like to compare it again to a criminal context, if the police, screw up just slightly, right, and they breach someone's charter rights when they're doing a search or what have you, then the criminal justice system is willing to let an accused person who's probably factually guilty be found innocent, to deter the police from violating people's charter rights. So the charter and the rules of evidence are strictly construed against the police for various reasons having to do with criminal justice theory. Not the case in civil procedure. We don't. We tend towards a liberal interpretation of these rules. So you can amend, and sometimes in some cases you can blow through deadlines. And again, it's not to say the rules aren't meaningful, but we're just a little bit liberal about how we enforce them on people. Okay. Okay, so that's true. 26.01, you can amend your pleadings on motion any stage of an action on such terms as just, unless prejudice would result that could not be compensated for by costs or an adjournment. So prejudice is an unfair disadvantage to another party, right? So that unfair disadvantage, that prejudice, could be a loss of money, it could be a loss of time, it could be a loss of the opportunity to present your case and be heard fairly. So in this case, what might the prejudice be? If the court simply said to the lawyer, Ross, okay, go ahead, amend your pleadings, put in the vacancy argument, what prejudice might that cause to? So it's not just a prejudice. It's not prejudice that MacDonald now has to respond to that vacancy piece, right? Because if the vacancy argument is a real argument, then it's fair that MacDonald should have to respond to that. So it's not just so people are getting at it here, right? So MacDonald is now, he's paid his lawyer to file pleadings initially. This case had gone through discoveries, which is to say the process of getting the facts out. MacDonald's lawyer had prepared for trial. And if Ross is now allowed to amend his pleadings, then he's going to have MacDonald have to go back to the drawing board. He's going to have to pay more legal fees to respond to this vacancy argument. MacDonald will be out of pocket relative to where he would have been had Ross done what he's supposed to have done and argued vacancy in his original statement of defense. Okay, so that's the prejudice, but as people are recognizing, this is prejudice that can be remedied by compensated for by costs or an adjournment. Okay, so we're letting Ross amend his pleadings. That amendment causes prejudice to MacDonald, but costs and an adjournment can compensate for that prejudice. And that's what we see the court doing at paragraph 30, right? So the court's going to allow the amendment. Back to the case. The court's going to allow the amendment. The pleadings will be deemed reopened. The plaintiff being allowed to reply, right? Because it would be totally unfair not to let MacDonald get his side of this vacancy piece out there. He may discover or rediscover any witness. So this means that he can question, ask new questions to Ross's witnesses. Then it gets to costs, right? So costs, when you see a reference to costs in civil litigation, at least in Ontario, that we're talking about the extra sums that a court will order, not with regard to the wrong that's being litigated, but rather with regard to something that happened in the litigation, or to the mere fact that the wronged party had to pay for the litigation in the first place. So what they're saying at paragraph 31 is that Ross is going to have to pay extra money to MacDonald to compensate MacDonald for the extra lawyer fees that MacDonald has to pay because Ross didn't argue vacancy initially when he was supposed to. Plus interest, right? Because Ross or MacDonald's going to be out of pocket for the interest. So these, is that only if MacDonald wins? No, because if Ross wins, the case itself, then MacDonald will have to pay costs to Ross, right? So a cost award can be made in favor of a successful defendant, just as in favor of a successful plaintiff. But because Ross pulled this stunt of seeking the last-minute amendment, if Ross does win, he will receive a smaller sum of costs from MacDonald than he would have had he properly raised the vacancy argument in his initial statement of defense. Okay, so paragraphs 30 and 31 are all about the court trying to, kind of have its cake and eat it too, right? It's gonna let this amendment in to make sure that a substantive legal argument, which could affect the just outcome of the case, is heard, even though the defendant didn't raise it initially. But at the same time, is going to do all this other stuff to try to make sure that the plaintiff is compensated for the prejudice which this late amendment causes. Okay, hopefully people are still with us here. It's a bit of a complicated series of considerations, but it's the sort of thing that at the end of a lot of the cases, you're going to find something like paragraph 30 and 31, where the court is trying to use costs and use procedural mechanisms to keep things fair, while at the same time trying to get at the truth. Okay. So we've got 2 minutes, which I think will get us into service. That basically brings us to the end of the pleadings by anything. Okay, so we're on this road, right? You remember the this long road into the mountains where justice will hopefully be done. We're following the conventional civil action from beginning to end. And step 2 is service. So civil procedure has special rules about how documents have to be delivered to the court and delivered to other parties. And these special rules are called service. This is what service is, right? And the rationale for having these special rules is that it's very important to be sure that everyone involved in civil litigation knows what the heck is going on, right? Because civil litigation has very important consequences. People can lose millions of dollars. They can lose custody of their children, as we saw in the very first reading of the course. And parties have to speak up for themselves, right? We do not have an inquisitorial justice system in which the judge takes responsibility for gathering all the facts and making sure that justice is done. That's not us. We have an adversarial justice system where parties have to speak up for themselves and put their best foot forward, present the evidence and the facts as they understand them. Otherwise, they'll lose, right? And they can lose things that are very important. And we can't have an adversarial justice system. We can't have audi alteram partem and people speaking up for themselves unless they know what's going on. Therefore, we've got these special rules for something which seems very mundane, which is basically about delivering documents to each other. Okay, so the first step that you have to abide by is issuing documents, right? So to issue a document simply means taking it to a court, having the court keep a record of that document, and then enter it in a database by which the court keeps track of the opening of all the ongoing civil litigation. And issuing a document also means paying a fee to the court for the privilege of doing so. So issue a statement of claim. No one in the court actually reads it at that time, but they do have it on file. So 4.05 talks about issuing through personal attendance in the court office, which means actually going to court and doing it. We are introducing electronic issuing of documents at a bizarrely slow pace. Ontario's been trying to do this for 20 or 30 years. We're finally kind of getting it. You can see filing civil case documents online is finally sort of a thing since only about 2015 or so. You still can't do it with all documents, and you don't need to know this, but the takeaway is basically that we are very slowly getting into the age, very slowly coming into the 20th century, and some documents you can issue online. Most, or many at least, you still have to physically deliver and have issued at the courthouse. Okay, so after issuing, we come to service itself. So when we talk about serving a document in civil litigation, it means delivering the document to other parties in accordance with these rules. It's sort of an archaic use of the word service. It's more like service in tennis than it is like service in any other context. I don't know if people. Okay, volleyball. Yeah, good point. It's not just tennis. In various sports, we put the ball into play by serving it, and likewise, you put a document into play by serving it in civil litigation. Okay, so the other thing about tennis, or about service is that there's different levels of service, right? So there's the gold standard of service is personal service. Okay, and where a document is to be served personally, that means if you're serving on an individual, you typically have to leave a copy of it with the person. Okay, so leaving a document with an individual for the purpose of Rule 16.02 does not mean mailing it. It certainly doesn't mean emailing it, nor does it even mean couriering it to it. It means physically handing the document or presenting the document to a person. So personal service on an individual requires leaving it with them. Personal service on a corporation means that you have to, again, physically have it delivered to that place of business, to the corporation's place of business. And we won't get into details, but you can't always just leave it with any employee. There has to be a certain level of managerial authority. So this personal service business is typically outsourced to, and David, no, registered mail is not adequate for personal service. So this is typically outsourced to a group of people called process servers. Here is Jen, who is a real process server working in the Windsor and Essex County area. So Jen will personally serve your litigation document on other parties if you call her, and give her the document, and she will do that. She'll go to the place of business. She'll go to the person's house if you're suing someone directly, and then she will provide something called an affidavit of service. which is a document where she swears that I actually showed up at this particular place on this particular date and handed the document to this person. Okay, so so why do we do this? Why do we have this personal service business? Well, it's supposed to provide the most certainty that we can possibly have that the person who is sued has actually received this document. So that's the upside. What's the downside? What's the cost, or why might this present an access to justice barrier? This personal service to have that time. Okay, and so in terms of access to justice, yes, this is expensive. Jen doesn't work for free, so it might cost $150 or something, or at least 90 or 100 to get her to do this. So tack that on to the cost of what it costs to engage in civil litigation. It's also kind of a hassle, right? It's one of the things that self-represented litigants, it's not intuitive. Like, we live in a world where people generally email things to each other, or send it through a text message or something, and so this is like a very formal requirement for delivering documents in the context of civil litigation. Can a third party other than a paid process server serve in civil claims? So that's a good question. I think the answer is yes. I should look that up. Let me write that down. Look that up. Whether you could get just anyone to deliver your. I'm pretty sure you can, because I know you can get, if you're an Articling student, to do this, and in family court, I think you can as well. Yeah, I did this when I was an Articling student, so yeah, I'm pretty sure the answer is yes. But they have to swear this affidavit saying that they actually did it. We'll talk about affidavits next week. Okay, so personal service. Okay, so the rules of personal service are in Rule 16. And they basically provide different things for personal service. What constitutes personal service depends on who you are serving. And I gave you the individual in the court, and there's various other ones if you're affecting personal service on a municipality. Yeah, so Facebook and all these other alternatives, basically you have to go to court, and so getting into substitute service, which will be for next week. But the 16.02 specifies a very small list of acceptable ways to affect personal service. Okay. So that's personal service is the gold standard of service, right? It's the one which is most expensive, most onerous, most formal, but provides the best assurance that the other party will have actually received it. Then we get into alternatives to personal service, which are kind of our silver standard for service. So documents that need not be served personally can be served in the ways specified in 16.03. So where personal service is not required, you can mail it. If a party has a lawyer, if they have a lawyer on record as representing them, you can typically provide the documents to their lawyer. And even in certain cases now by email, the rules are very reluctantly and tentatively allowing email to be used in certain circumstances. There's no email at all allowed for 2014, and still it's not just any email, right? It's got to be an email with the name and telephone number of a person to contact in the event of a transmission problem. And so on, right? So again, we're being formal, and we're being quite punctilious in terms of trying to make sure that documents do not go amiss, and make sure that everyone knows what's going on. Okay, so our personal service requirement applies to originating process. So So what do you think that is? Okay, so here we go. An originating process, 16.01 sub 1. It's originating process that has to be served personally. What do you think originating process is? What does that mean? Okay, so it could be the first pleading. A statement of claim would be an originating process, but a statement of claim is not the only originating process. What else might constitute an originating process, thereby necessitating? Kevin's got it. That it's when a new party is being brought in for the first time, right? So there's a certain logic here, right? If you are being brought into litigation for the first time, whether that's because you're a defendant being served with a statement of claim, or because you're a third party who's being brought in with a third party claim, the law insists on that higher, more expensive, but more certain gold standard personal service for you. Whereas if you're a plaintiff receiving a counterclaim, right, or you're an existing defendant who's being served with a cross claim, the standard is a little bit lower because at least you know there's already litigation going on. So we're going to let the other party get away with doing something which is not, just Facebook or WhatsApp or whatever. It's still service requirements, but it's an alternative to personal service. The silver standard, a little bit more liberal. Okay, so an example of non-personal service. So any document that is not required to be served personally. So you can be served on a lawyer, for example. So a motion record would be an example if you're bringing a motion against someone, or a counterclaim, a statement of defense and counterclaim. You recall this is the defendant's response to the statement of claim. A statement of defense and counterclaim is not an originating process. Therefore, the defendant can provide that to the plaintiff's lawyer, right? The plaintiff serving the statement of claim has to do that by personal service on the defendant. The defendant does not have to serve the statement of defense by personal service on the plaintiff. They can't just do whatever, but they can use this silver standard, which is laid out here. Okay. All right. So I think the last thing I'll say for today is that in certain circumstances, it's impossible to affect personal service because you can't find the person. In those circumstances, you have to go to court to get permission to deliver a document to the other side through an alternative to personal service. That's something you'd have to bring a motion about, and we'll talk more about that on Tuesday when we get text or email at any time.